apologize for the longer 2 minutes than usual, but we will now proceed to the third and final case for the day, which is Estate Chalket Hole Landowners Association, Inc. versus Cenni and Max Arc, LLC. This is number 15 of 2023. So you may proceed.
Good morning, Your Honors. Gregory Adam Thorpe of Dudley Rich on behalf of Appellant Estate Chalket Hole Landowners Association.
Okay, we're going to try to see if we can get this
I'd like
to be louder. For some reason, I know that you are not normally a quiet person. So
yeah, no one really struggles to hear me.
Okay, all right.
I'd like to reserve 3 minutes for rebuttal.
Very well.
May it please the court?
Yes, you may.
I would usually begin by standing up here and saying what this appeal is about, but given the record in this case, I think it's more useful to say what this appeal is not about. The issues that decide this appeal are not issues of fact. Rather, appellant challenges the effect of the application of section 2.13 of the Third Restatement of Property is articulated and adopted by this court in Strybeck to the facts. In fact, appellees on page 8 of their brief agree. They say that this appeal presents a question of the application of law to fact, and in its essence boils down to the legal effect of the plain language of the documents and maps involved. And so, in light of the evidence, we believe it's clear that in 1962, when the T62 map created this ROW, vehicular access was never intended. And if that doesn't convince the factually,
what was never intended?
Vehicular access across this ROW. In Strybeck, this court made very clear the existence of an easement does not define its scope. You have to have evidence of intent of a scope, and it said the Superior Court erred when it determined the scope just because it determined the easement existed, and specifically remanded for the plaintiffs to present evidence of scope at a trial. And so we believe that all the evidence points to the exact opposite conclusion, that at the time the ROW was created.
The fact that it's a 20-foot right-of-way would what, indicate a pedestrian as opposed to
Well, if a 20-foot right-of-way were sufficient to indicate vehicular development, Strybeck would have never been remanded. And they said that a 20-foot ROW on a piece of paper isn't evidence that its scope, it was intended for vehicular access. And indeed, our zoning laws were adopted in 1973, 11 years after this map was there, so our zoning laws offer very little insight into what was intended in 1962. Additionally, we believe that if it was ever intended, then in the 1980s, before this was ever acquired by appellees, the scope of it was restricted to non-vehicular access, and appellees had notice of that. Therefore, the court's conclusion that the law of bona fide good faith purchaser for value led to a conclusion of not notice on these facts was wrong. In issue 2, we challenged the trial court's conclusions, first, that appellees ever met their initial burden. The map that they relied on was a smaller 27-year later map that addressed smaller parcels and had a reference to the original map in T62. Those facts are almost completely analogous to Strybeck, which relied on the T89 map that had a small notation that said this easement is the easement that was on the T57 map. And this court said, well, the T89 map in Strybeck is irrelevant. It's the T57 map that defines the easement rights. And if the T88 map had been binding, the court wouldn't have said 11 different times in the Strybeck opinion that the T57 ROW is where it is on the map and not in the alleged dirt road. The court would have just held that the T89 map created the easement in the dirt road, but it wasn't. They remanded it. They said as a matter of law, it was error to conclude that the T88 map defined the easement. And we believe that that's just as reflective here. The T62 map plainly distinguishes between a road and an ROW on this specific access. And in Strybeck, the rationale of it was road means road and ROW means ROW. a road comes with vehicular access. An ROW requires the plaintiff to provide evidence. Therefore, we're remanding this for you to prove evidence of scope included vehicular access in 1957. The Superior Court did not apply Strybeck in that matter. The Superior Court read it and said, oh, you established that an easement was intended, therefore its scope is vehicular. That's the exact error that this court reversed in Strybeck. In issues 3 and 4, this is where we address the record notice. Procedurally, one addressed summary judgment and one addressed trial. But the argument is the same, that the record evidence where the release of the settlement agreement specifically acknowledges that all of the obligations of the settlement agreement were performed. And the language of that settlement agreement specifically says in the 4th paragraph that after reciting the settlement agreement and that Assoc fully performed, that the release was being executed pursuant to the terms of the settlement agreement. It didn't say in there, and they could have easily written it, that Assoc, or at that time his estate, was fully released from its obligations under. It didn't. It said the release is being given pursuant to the terms of the settlement agreement. That's a strong difference in language. And in issue 5, we argue that the trial court's conclusion, in light of Cenni's testimony and his title agent's testimony and their reliance on T89, that it was error to conclude that Cenni lacked actual notice of this, and that he lacked imputed notice through his title agent, specifically hired and contracted to determine these errors, who then listed it in the title exception. As to the undisputed facts, I want to point out some that lead to why we conclude that the elements of the cause and action completely failed. There's no dispute that the T89 map references the original T62 map, just like T88 and Strybeck reference T57. There's no dispute that the T62 map was a more detailed map of this portion of the subdivision. The subdivision was huge, and they didn't do one comprehensive map. They did several comprehensive maps to fairly large portions. In footnote 15, this court specifically said that the more detailed and comprehensive map is the one that's controlling. It rejected the T89 map there. The T62 map in this case specifically distinguished between a road and an ROW. And that finding is in the joint appendix on page 14 and on page 282. And the specific access on this map distinguishes along the way between a road and an ROW. Cenni's deed only referred to the T89 map, and the T89 map only referred to a T62 ROW, not a T62 road. The T89 map was...
Let me ask you. You agree that the only issue really here is whether or not the court erred in finding an easement by implication, correct?
In the broadest sense of it, yes, it could be boiled down to that one issue.
I mean,
there are some legal issues that break down where I can make more than one point of error.
There was no cross appeal on, the negligent or intentional misrepresentation.
There is nothing like that.
So then the only issue really is, was an easement by implication properly created? And I guess your argument is that under restatement 2.13, I believe you're arguing that the grantor did not have the power to create the substitute?
We're making two arguments. First, that he didn't have the power, and if he did, they had, and second, that the evidence of intent does not establish an easement by implication. And second, we argue that he had notice. He wasn't a bona fide good faith purchaser for value.
But if the court properly found that there was an easement by implication, then you would just have to determine the intent, and you wouldn't have to reach whether the notice.
I would agree with that, yes, Your Honor.
Okay. So why didn't Assoc have the authority or the power to create the servitude was it 89?
In 89, because based on the T62 map, rights were already vested. The complaint in the Bachman litigation makes clear that starting in 1958 already, Massac made contracts and deeded them out and granted rights. And so if Massac wanted to change those rights, he needed to have all ownership interest in this. That's what was held in Pavel. You can't change restrictions on land unless all of the owners in there vote so. And that couldn't happen. After deeds were made giving rights of access to these common areas and the access ways, those rights were vested in the purchasers. That was the whole point of the Bachman litigation. The Bachman complaint is in the joint appendix. You can read it.
But you had a settlement.
And it memorialized that original intent. It said,
right.
Yes, in fact, Massac may be arguing otherwise, but we are confirming the plaintiffs in Bachman's understanding of their contractual rights. They agreed to that.
Well, there was the Bachman litigation. Once the association came into effect, they joined that litigation and filed a lis pendens.
Yes.
Correct? And the lis pendens, I guess you can consider the settlement a judgment, so to speak, and that was recorded.
Yes.
And that showed that although the quitclaim deeds were not recorded, that set out that Massac would create a new map, a new subdivision. It would provide, it would convey the parcel, which became 557, to the association. And I guess those deeds were to accomplish that. The one creating 186, conveying 186, and the interest in 577, correct?
Yes, correct, Your Honor.
Okay. Was that a valid conveyance?
That holding wasn't challenged here, but as the Superior Court held, it was valid is between Massac or its estate and ECLA, as well as any person with notice of the restrictions in there. And so the only way that the appellees could succeed is if they were bona fide good faith purchasers for value, or there was some original intent that this should have been developed for vehicular passage.
But did the settlement agreement provide sufficient description of the property that was being conveyed?
Yes, Your Honor. It specifically said that the access to Heart Bay Beach was to be...
I'm talking about the conveyance now, because I'm talking about the conveyance of 557 to the association.
Yes.
Because if it was not conveyed to the association, it would still be Massac's, correct?
Subject to the restrictions in the prior deeds that restricted its
regardless
use.
of that, it would be Massac's property, and he would have the power to create an easement by implication, couldn't he?
Yes, as long as he hadn't given vested rights to the contrary elsewhere.
Okay. Was the description in the settlement agreement, which was recorded, and even the description in the quitclaim deed, was that sufficient? We had referred to a map that was not attached, and that map had restrictions as to exclusions based on a red marking. And if the description was not sufficient, wouldn't that conveyance fail and the property remain as Massac's?
Two things. Factually, there was a map attached. Starting on page 1797 and going to page 1802 of the joint appendix, Kasner is cross-examined about the settlement agreement and the map with the shaded area. And despite all of his efforts to avoid...
Was there ever a map attached to the quitclaim deed that was signed by Massac conveying it to the association?
I don't believe so, Your Honor.
So then how is the description of the property that's conveyed sufficient enough to convey it under the VI code?
I would say that that's not an issue on appeal. The court found that. It hasn't been appealed. It said that the deed was effective. And our argument about the deed was, one, it's evidence of a lack of intent by Assoc because he already conveyed any rights and they were restricted. And two, that the court held the only way that the appellees could have claims is if, in light of that deed, they had to be bona fide purchasers for good faith, for value. And so, but we've argued that Cenni read the settlement agreement and understood it, and Kasner read the settlement agreement and understood it. And on page 1802, Attorney Mollenberg does a great job of cross-examining Kasner, where he ultimately admits that there were exactly 2 roads going to Hart Bay, and despite the shading, he could identify those 2 roads which were to be restricted according to the settlement agreement. Literally, I see no other black lines than that one. So no. That's Cenni's title agent, who was hired for this purpose, testifying that you can understand the restrictions in light of the settlement agreement, which Cenni admitted he read. Cenni said, upon examination, he said that he had read that the ROW would remain undeveloped and that Assoc had to convey it and that it acknowledged these obligations were performed. And in his exact words, he didn't pay attention to this. He further admitted that, in spite of the express acknowledgement that these obligations were performed, that it didn't seem to be an issue by his evaluation. That is in the joint appendix on page 1729, 1758, 1761 to 62, and 1789 to 90. And a failure to appreciate the meaning of those words is not a lack of notice. If that were the case, the jurisprudence on statutes of limitations barring causes of actions would be completely different. How many cases are out there where all of the facts were in the plaintiff's knowledge and we say, well, you failed to act on your rights? Here he admits he read these. And the court says, well, that's not actually notice.
Okay, thank you.
Thank you, Your Honor.
Court, Justice of the Court, my name is Daryl Dodson.
Just the mic so you can hear.
How's this? Is that a little better? Daryl Dodson, I represent Max Ark in this appeal. Adrian Cenni was a party below. All claims against him were settled before trial, so it's only Max Ark in this appeal. And first I'd like to point out this is an important case because if it turned out the other way, it would have had a devastating effect on land titles in this jurisdiction. Because everyone took it as a...
Try to speak in front of the mic because that's the only way we can get it on the record.
Okay. The practitioners and title insurers...
Bring it up a little bit and speak directly into it. Yeah, not that high. Okay.
How's that? Right. Is it too loud or not loud enough?
No, it's not. No. Yeah, we want to make sure that you stay in front of that mic, and because everything is being recorded, and if it doesn't, if you go off to the side, you miss it.
Okay, I'll try to stay still, Your Honor. It's hard for me. Anyway, what I was saying is everyone took it as an article of faith that if you had an R1 parcel with an official map that showed road frontage on it, you had an easement to use that road. It's a common sense thing. If you have a road that runs along your parcel, you can drive your car up and get access to your lot. And when Adrian Cenni purchased this lot, the court found nothing, the record was devoid of anything that would give him constructive notice that there was any restrictions on his rights. And his investigations didn't do anything to give him actual notice that ECLA had any claims whatsoever that he couldn't use that road to drive his car down to the lot. ECLA's claim was that an owner, they've never denied that the lot was developable, but they said if you want to develop it, you got to bring every block, every bag of cement in by hand like an ant train down a 220-foot hiking trail. In fact, you can't even park to bring this stuff in. You have to park outside the ECLA property, outside of State Chocolate Hole, because the only parking is at the beach, which is temporary, and you can't park along the road. And if you want power, you have to provide your own wind and solar power because you can't have utilities running to it. That's what we were facing, and that's what caused this lawsuit. But after 20 years of trying to thwart development by ECLA, after 3 years of litigation, a trial that lasted 4 days, the court finally agreed with Max Ark that it had a right to access along what we call the access road, shown on the official drawing D9325 T89. And the court reached this conclusion after properly applying the Strybeck test, which is section 2.13 of the Restatement of Property, and finding There was no constructive notice that would impair his title. There was no actual notice of any restrictions. Now, I was very confused by that presentation we just heard because it didn't sound like an appellate argument. I mean, the appellants don't challenge the legal test that the court applied. And they don't, at least not clearly, argue that its factual findings are clearly erroneous. I mean, really what this appeal is about is they are re-arguing the evidence and saying the judge reached the wrong conclusion, but without ever saying that what he decided was clearly erroneous. And they've thrown in a bunch of new arguments and other things that weren't preserved below. I mean, one is this argument about the T62 versus T89. I got to say, I was completely confused by that. It was not raised below by Rapp-Meilenberg. It was not raised in their initial brief. I don't understand it. T62 divides out parcels on one side of the road to the east side. T89 divides them out on the other side. I don't really understand the argument. In any event, I would argue the court correctly applied the test of Strivik, and ECLA, interestingly enough, almost concedes this in its brief. It concedes at page 17, 2 of the 3 elements. It says, yes, the court correctly decided that there was a conveyance by reference to an official drawing, and number 2, there was a depiction of an easement on that drawing that performed a boundary of the parcel. They concede that in their brief. It challenges only whether Massac had the power to create the servitude, and it relies on that 1986 roads deed that you just discussed, but it completely ignores the court's explicit rejection of this assertion for the reasons, Justice Hyde, you just pointed out. It began by analyzing the recording statute, and it concluded the 1986 roads deed is unenforceable against Max Ark because it was never recorded, and ECLA has not demonstrated that Max Ark was aware of it, period.
But is that correct, though? The fact that it isn't recorded doesn't avoid it, correct?
No, it is, and actually, that was the previous part of the court's finding.
Well, the court seems to consider it void because it wasn't recorded, and that's not exactly correct.
I don't think anyone said it was void because it wasn't recorded. Here's what the court said. An unrecorded deed would be valid and enforceable in a dispute between a grantor and a grantee, but this dispute is not between Massac and ECLA. It is between ECLA and a subsequent grantee of a Serbian estate who didn't record its 1986 deed to the Serbian estate, and Max Ark, a subsequent third-party purchaser for value of a dominant estate. As a result, the court has to follow the recording statute. It's invalid as to Max Ark. So I don't understand how they can
The settlement agreement was recorded, which set forth the requirement of, for the deed to a new subdivision to be created, for these road parcels to be conveyed to ECLA, and that was recorded. So why isn't that noticed?
Well, because it was not released, and not only released once, but released repeatedly. In 1989, ECLA recorded a release of lis pendens, not just as to parcel 501, but as to the entire litigation, saying, we have no further rights that arise out of this litigation. Then they recorded a consent judgment, which subsumed that settlement agreement and said this constitutes, if Massac fully performs a consent judgment, which required him to do a survey and formulate a plan that was supposed to incorporate all those aspects.
But the earlier release was recorded after the deed to the parcel was recorded.
No, that's not true. The settlement agreement release was recorded in 1999. And that
I'm talking about the recording of it. The first release that was given to Horst.
Of lis pendens.
Right, and that was recorded, I think, like 3 days after the deed.
Her deed.
Her deed. So it was recorded initially.
Yes. It was a release of lis pendens, a consent judgment, which subsumed the settlement agreement. And then
I thought that the court found, since the release was after, that he was charged with notice of what was on the record before.
No, it was the release of a consent judgment was recorded in 1999.
But I'm not talking about a consent judgment. I'm talking about the release.
I'm sorry, of the settlement agreement.
Right, the settlement agreement.
Of the settlement agreement and the consent judgment. It released both of them. and it wiped them out completely. And the recorder exited off the index and wrote in the margin, canceled, okay? And when Castor did the title search, he got a little lazy. He carried over the prior policy, and he admitted in his testimony it was a mistake. It was a mistake to include it. But Judge Dunstan dealt with that as an opinion. He said ECLA is arguing that just because the title insurer mistakenly listed something which had been released, that doesn't restore its vitality. That doesn't like bring it back to life. So that was completely wiped out by that. And the sections, sections where Cenni testified were completely miscited by my opponent. Raph Meilenberg says, were you aware that there was a title exception in your policy in 2004? This is on page 1758. And he said, well, no, I only became aware of it in 2014 or 2011. That's years after he got his deed. And he said, okay, you're saying you weren't aware of the settlement agreement at the time of your purchase? And he said, yes, I didn't pay attention to it because, are you saying you knew of it or you did not? I'm saying I didn't pay attention to it. So you didn't know of it, but you didn't pay attention to it? I'm saying I don't know. So he was saying it wasn't until, he didn't know about it until after he took title. But in any event, it was released on the record. They released all their obligations. So I'm not sure exactly what my opponents are challenging or how many of the things that they mentioned in their brief are still have vitality in this appeal. The court held several things. First of all, it helped correctly concluded that the documents ECLA recorded weren't sufficient to put Cenni and Maxark on constructive notice. And the court said, and this is a factual finding, the recorder of deeds was devoid of recorded documents providing Maxark with constructive notice that the Backman settlement agreement still limited the right to use this easement as anything more than a footpath, period. That's a factual finding. Is it clearly erroneous? So it's suspect now. Our opponents, nowhere in their brief do they use the words clearly erroneous.
Court used the fact that there was, this right of way was along the boundary.
Yes.
And would that have been important in this case, or that would have gone towards an easement by necessity as opposed to implication?
Yeah, we're not contending easement by necessity. We're not contending express easement. It's just strictly an implied easement. And the law is clear, as this court held. If you take title to a parcel and one boundary is a roadway, there's an implication, there's an inference, there's a...
But was the roadway ever listed as a boundary for this parcel?
Yes, yeah. If you look on T89, you'll see that's the western boundary.
I know it went along, but did it describe the parcel as bounded by that roadway?
Well, I haven't looked at the meets and bounds, but I'm sure that's what they describe. I mean, that's where the parcel is.
Did the deed in a way make reference to that roadway as a boundary?
Well, it made reference to easement A, which is a part of that roadway. And the only reason you would have an easement A, it's a parking and a turnaround area.
I understand that, but you're kind of mixing in the arguments because you're arguing the section that says where a boundary is a roadway, then you can assume that you own to half of that, half of the roadway if it is a boundary. But in this case, on parcel 501, there was never a reference to the roadway as being a boundary.
Well, it's depicted on the map. And
I understand that, but the deed didn't reference, didn't list it as a boundary.
True,
and I think that's
yeah,
what the law applies.
And you're correct that back in the day, deeds attached to meets and bounds, and they listed all the boundaries. But of course, modern deeds don't do that. You don't need that for cadastral to get an attest. All you have to do is refer to a map, and that T89 map shows that the western boundary is that road.
Well, let me ask you this. I am looking at T89. I have it in front of me. And what we are talking about access to 501, parcel 501 and 502.
Yes.
Am I correct? Well, it seems as if that from the map here that I'm looking at, parcel number 501 and 502, each one of them would have some kind of access, but it wouldn't have the kind of access where you would have perhaps vehicular traffic because vehicular traffic in the Virgin Islands, I think, is 30 feet wide. And the one part of which is a right of way, say 10 feet, that abounds 502. And then on the other one, we have a right of way of 20 feet. What is he looking for? They're looking to get access, vehicular traffic access to 501 and 502?
Yeah, we're not dealing with 502 at this point. That's
501.
owned by Miles Thayer. But the important point, this point about the 20 feet, is something that was belatedly raised in this appeal. And it's interesting because our expert, Ryan Weishart, testified that, especially in 1989, 20 feet was more than adequate for vehicular traffic and would indicate that that roadway was intended for vehicular use. And then ECLA called its expert, Larry Best, who was expected to rebut that, but he was silent on it, and his opinion was silent on it. So the testimony in the record was unrebutted that 20 feet at that time was more than adequate for vehicular use, and that was the intent. I'd also like to say something about road versus right-of-way, and that is, this is another argument that was not raised below. No one ever looked at the map and said, because the beginning part says road and the end says right-of-way, therefore only the beginning must have been intended for vehicular use. That was not raised above. And I also would like to point out that the president of the association, who's here today, testified to the contrary. We asked her, would it be okay if the road extended part of the way down and only the bottom part was condemned? And she said, oh no, that would violate the settlement agreement because the entire thing has to be a footpath. So their own theories are at a war with each other. But in Strybeck, there are parts of Strybeck that differentiate between a right-of-way and a road, but there are two parts of Strybeck. One dealt with the express easement, the other dealt with the implied easement. And there the court looked at the deed and said, the deed gives an easement over roads, but it doesn't mention right-of-ways, and therefore there must have been a distinction intended. But nevertheless, it found there was an implied easement for the right-of-way. So the distinction between right-of-way and roads has nothing to do with implied easements. And certainly the court didn't hold, as a matter of law, that there's a distinction between roads and right-of-ways. My time's up. I would just like to say one quick thing, and that is I would just urge the court not to remand this case for factual findings.
Is that what?
I would urge the court not to remand this case for further factual findings because it was a teeth-pulling process to even get this decision. This case went on forever. We expended $250,000 in attorney's fees. We finally had a trial, and then Judge Dunstan retired. And it took from 2018 to 2022. I finally had to write a letter to the presiding judge to get a decision. Judge Tejos, who's taken over his docket, has made it clear that this is not her case. She's doing nothing with it. So that's why I would ask the court to affirm this and not remand it. Thank you.
Thank you.
Morning again. I want to first response. This court exercises plenary review over the Superior Court's application of law. In Strybeck and White v. Spenceley, it said, undisputed evidence of contractual intent is a question of law. We have not challenged that the T-89 map says what it says. We have not challenged what the settlement agreement says. We have challenged the trial court's conclusions in applying Section 2.13 and the law of bona fide good faith purchaser for value to the evidentiary facts established in this record and said that they came to the wrong conclusion. That has been our argument. There is no need for remand, and we've never argued that the evidentiary facts were clearly erroneous, except for we do ask for a correction of some factual points in the record, 2 of them. And appellees concede that one of those was, in fact, an error in writing the judgment that was wrong when the judge wrote it. I also want to point out that Strybeck made the exact argument Cenni is making here, and the court rejected it. Strybeck argued that he didn't have notice of the T-57 ROW, and this court said that the depiction, the notation of the T-57 ROW on that T-89 map was sufficient. On page 509, It says, the depiction is therefore also sufficient to have given Strybeck notice when he purchased the property that it was likely encumbered. You have the exact same factual scenario here with the T89 map referencing T62 and saying this is the T62 ROW. I would also point out, as I said earlier, the release didn't release all rights under the settlement agreement. They could have used that language. They said that Massac's estate was released pursuant to the settlement agreement. That is a difference in language, and that difference has meaning. Additionally, the property description, I have to say, it does not state, it does not use the ROW as a boundary. This is under the section of 2.13 of the restatement that says a map reference. The deed unequivocally referenced a map. That map then daisy chained, just like in Strybeck, to the earlier map that defined the ROW.
Isn't it clear that, that Massac intended that this be a right-of-way for vehicular traffic?
In 1962, I don't think so.
Council has argued that this 1962 argument that you're making is a new argument to this court. And I don't recall that that was an issue below.
The ECLA absolutely argued that this was not intended to be a vehicular access.
But it's Massac's intent, right? Is that?
Yes, and ECLA argued that intent didn't exist.
Indeed, in this case, it clearly says that the owner would be responsible for any damage caused to this roadway by any heavy equipment that it brought to its property during its construction. Does that indicate to you that it's, that it's intended to be constructed on?
The T89 deed, correct?
What?
The deed referencing T89,
Yeah.
a 27-year later map that attempted to alter the original intent?
This is what it's referring to. If there's any damage to the right-of-way by any heavy equipment or otherwise, that the owner would have to fix that. And it also referred to the fact that there could be no garage or any other thing built before the house was constructed. And doesn't that indicate, at least if you have a garage that's intended for vehicular, for a vehicle?
I would say that is this court held in both Strybeck and Sam's Food, and in the McBurney case, which this court relied on in Strybeck, that's irrelevant. What has done 27 years after an ROW is created and rights are vested is absolutely irrelevant to the definition of the ROW. It's the evidence at the time. Massac deeded in reliance on the T62 map, and those rights were vested simply because he attempted in 1989 to write a deed that altered that isn't evidence of intent in the surrounding circumstances when the ROW was created. This was held twice by this court, and it was expressly stated in the McBurney opinion that this court relied on in Strybeck. And so what Massac did in 1989, and he was literally, that's why he was being sued. He was trying to avoid his commitments in what was contractually obligated in his intent in 1962. That is the purpose of the Bachman litigation. And the settlement agreement addressed that, and he had notice of that. So just because he tried to get around that 27 years later doesn't change the original definition. And just like in Strybeck, the reference to T62 on his map was sufficient to have given, in this case, Maxark, notice when they purchased the property that it was likely restricted in scope. I'm reading right from the analysis in Strybeck, and the facts aren't different. And appellees haven't given a distinguishing set of facts to change that.
Okay, thank you.
Thank you, Your Honor.
The matter will be submitted.